So, with this background, let me move on to the discussion on law on negotiation. There are two provisions which I have taken up for discussion. The provision one is that is section 80 of CPC. When a person has supposed to file a matter, a case in the court against the state, either the state government or the central government or a public officer, he is supposed to give 2 months notice. The question is, when I file a case against any other private party, I need not give notice. Why notice should be given to state only? So, this question was answered by the court in Bihari Chaudhary versus State of Bihar. The court said this 2 months notice, there is an interesting reason behind it. The reason is those 2 months will be utilized by the state to resolve the dispute. They first investigate the wrong done, if they will try to contact the party, they will try to negotiate with the parties. If they find that they are at fault, they try to resolve the dispute amicably without going to court. That is the purpose of this 2 months notice. Again, this 2 months notice has exceptions also, that if the matter is of urgent emergency, then the court can waive off this 2 months notice requirement and they can take up the matter directly without giving notice. This is the objectives of the law, but actually what happens? Sadly, the 2 months is never utilized for negotiating and settling the dispute. 2 months are instead utilized for preparing brief that could be presented before the court. So, even Law Commission of India felt that the object of the section 80 has not been fulfilled, has not been understood by the state, and it has been just dead letters in the statute book. So, this is about section 80. The other one is compromise decree. So, when the matter is filed before a court and when the court is going through the matter, whatever may be the stage of issuing a summons, stage of trial, whatever may be the stage, the parties are free to negotiate outside the court hall. So, when they negotiate outside the courtroom and they try to settle the dispute, it is very much within their powers. So, what happens here is court encourages outside the court settlement. Whatever is settled outside the court can be converted into decree of the court. So, what happens here is we are agreeing for something for which you are getting the seal and signature of the court. It is as good as a decree, as good as enforceable right under the law. So, what happens here under the compromise decree process, there are two important things which attracted my attention was suit adjusted wholly or partly could be presented to the judge. So, we can present half cooked negotiation agreement to the court and the court would say that 50% of the case is resolved through negotiation, remaining 50 I am going to decide based upon the evidences. So, when suit is adjusted partly, the remaining part would be taken up by the court. The other issue is another interesting one is proved to the satisfaction of the court. So, once a settlement agreement is brought before the court, converting that settlement into decree of the court is not a mandatory process. You can't force the judge to sign it, and also second thing is it is not a mechanical process also. Now, judge has to take two precautions. Number one, whether the negotiation process involved any kind of mistake, misrepresentation, fraud, coercion, those chances should be ruled out. So, that means he should ensure that consent is a free consent. Second, he also should check the terms and conditions in the settlement agreement, whether they are within the ambit of the law, within the limits of the law. So, only once he is satisfied with these things, he is going to convert it into a compromise decree. Then there is notice, the issue of notice. Whenever notice is issued, the object is that can't you settle their matter rather than going to the court, but mostly the notices are responded with a counter notice, matter ends up in the court. But this is an attempt by the law to encourage negotiation. Let me move on to mediation from negotiation. Now, here again definition of mediation, I call it as an improvement over negotiation process. I term it as an evolved and improved version of negotiation. Why it is an improved and evolved version of negotiation is because that there is a third independent impartial person who is manning the whole process, and the presence of this third independent impartial person is going to ensure that the negotiation runs on track without any delay. So, it is the third party who should possess two important qualifications. Number one, as I mentioned, independent and impartial. So, he should not be connected with neither of the parties, and in his behavior he should not show that he is going to favor any of the parties. In addition to this, he should also enjoy another qualification, that is trust and faith of the parties. Parties must have faith and trust in him, then only the mediation can go effectively. So, his role is avoiding deadlocks, so that the discussion is meaningful, and then facilitating the parties to come to a settlement of the dispute. So, how does he achieve these things, avoiding of deadlock and facilitating the parties to come to an amicable settlement? He would do that by following a procedure which is similar to those principles which I had made mention while discussing negotiation. First, he would identify issues involved in the dispute, that is identifying interests. He would try to reduce misunderstandings, means he is going to develop a proper communication between the parties. Clarify priorities, means he is identifying the interest of the parties, he is identifying the expectation from the negotiation process. He would explore the areas of compromise. So, what he is doing here is he is generating options, assisting the parties in generating options. He not only generate options by himself, he would assist the parties to come up with the options. Mediation has been predominantly a non-statutory authority. No law proposed mediator, he always worked outside the scope of law, but always he was successful in resolving the dispute. Whatever he achieved would be converted into an agreement. Agreement means a contract, and contract could be easily enforced. But things changed from the year 2002. By insertion of section 89 of CPC, the mediation became almost a statutory authority, because now he is coming within the ambit of law, and in a court annexed mediation he is going to function under the laws of mediation. So, under section 89 of CPC, it is important to note that it was the recommendation of Law Commission, that is 129th report of Law Commission recommended that we should go for ADRS and encourage people to resolve the dispute. The recommendation got the support from an experience of Himachal Pradesh. Conciliation courts were set up in Himachal Pradesh to resolve rent disputes, and the success of that experiment at Himachal Pradesh encouraged the legislatures to come up with this amendment. Later on, as usual, the matter was passed in the year 2002, it became a law. Later some issues was raised, most importantly the constitutionality of section 89. When this was questioned, court disagreed, they said it is very much constitutional. Then there was another case, that is Afghan's case. This Afghan's case 2010 is, they found there is a lot of defect with the drafting of the law. So, they say that if the law, that is section 89, is implemented literally as written, it will be a trial judge's nightmare. It puts a cart before the horse and lays down an impractical, if not impossible, procedure. So, they are finding that there is a basic flaw with the drafting of the section. That is what Supreme Court felt in Afghan's case. So, let me understand and let me explain the procedure under section 89, then you can go ahead with your own opinion whether it is the cart before the horse, or what you can make out. So, what happens here is, first the judge is going to make the list of admissions and denials in plaint and written statement. Each admission is fact admitted and fact settled. Denials, fact needs to be heard, though those becomes issues, and then he is going to check the chances of settlement. Now, here how he is going to check the chance of settlement without hearing the parties, that is the issue. Formulate terms of settlement. How is going to formulate terms of settlement based on only those two documents, that is another issue. So, once the terms of settlements are formulated by the judge, it should be communicated to the parties, and parties would submit their recommendations and observations within 30 days, and there would be reformulation of the settlement agreement. And this procedure seems to be a little too early to resolve a dispute. It should have been postponed at the later stage. That is the opinion of the court under Afghan's case.